welcome back to Truth and Transparency. This is Scott Peterson's coverage of his habeas corpus that was filed. This is episode 3. I'm going to start with this clip, and then we're going to jump into it. Listen to the reasoning for how they manage the media.
And you mentioned right off the start that you haven't been in the media.
No. It was for the first 3 days or so when she disappeared. It was an absolute privacy issue, not showing the grief of our family, not exploiting that. After that, it was a conscious decision to remain out of the media eye, decided upon by everyone in the family and the volunteers, in order to, and I'm sorry to say it to media, but to keep the media here, to keep them hungry for, an interview with me or a picture, so that they would keep coming back, so the story won't fall through the cracks as it has happened with other missing people, with other abductions. And it's up to the family to keep that going. So we made that conscious decision together that I wouldn't speak. Obviously, we did lots of media with the rest of the family. And to keep them here, I didn't. But unfortunately now, the suspicions of me have grown so great due to people, wondering what happened to the, inappropriate relationship that I had with Amber Fry, that it's necessary to speak. It's appropriate time to, in order to ask people to keep looking for Lacey, because they're not looking for Lacey as much as they should be right now.
Let's talk about some of those suspicions, because there are a lot of suspicions out there. I think people want to know, first of all, why would you leave Lacey, who was 8.5 months pregnant, alone to go fishing on Christmas Eve?
Okay. Our day was planned for, Christmas Eve dinner at our mom's house. Preparations were all made. Gifts done. Lacey was simply going to be baking that day. And it's not uncommon for us to, simply, we have separate pursuits. She does not, play golf as I do, which was my other option for that day. And being, 7.5 months pregnant, she's not going to want to go out in a boat. But it was simply a leisure activity to pursue that day. And, it was what our plans were. It may not be everyone. It's the way that our relationship works.
I know when I you on Amber Fry, and I told you that I would be reporting that you had a girlfriend.
Right.
Your response to me is that you had no comment either way. Why didn't you just come clean then?
Well, I'm glad you asked the question. It simply, wasn't appropriate to comment on it. And unfortunately, there has been a statement in the press that I denied it, which was made with another reporter when I characterized a National Enquirer article as a pack of lies. And I did so without reading the article, unfortunately. The article I thought to include, and I know also included a supposed life insurance policy, supposed blood evidence, and I forget what else, but also included the report of Amber. So I called it a pack of lies, not knowing that she was in there. So it's just not important to comment about that. I'm glad that Amber came forward. You want me to turn that off?
Yeah, what is that?
That's my phone, unfortunately. I thought it was off. And I'll just answer that question again. Somewhere here. Yeah, it's kind of going crazy, isn't it? Okay. Yeah, so if you just want to ask your question again, I'll just...
So, once again, if you can just talk about why didn't you just come forward at the time when I asked you if you had a girlfriend? Why didn't you just come clean then?
Right. At that time, it wasn't appropriate to comment about because it's not relevant. And I'm glad you asked it because there were reports that I denied it. when I characterized a National Enquirer article as a pack of lies that included, unknowing to me, I knew that the article included this supposed life insurance policy bought this summer, supposed blood evidence, and other strange reports like taking the floors out of our home. And I didn't know it included, this relationship that I had. So I characterized it as a pack of lies. And that's come out as a denial. It was never intended to be. I simply approached that issue as it's not relevant, and there's no reason to comment about it. There's a reason to comment about the number. Now, I'm glad that Amber did the press conference. I'm glad that she came forward, because it allows lots of people, I believe, to start looking for Lacey again, because it's slacked off because of that, because there's suspicion about me.
She claims you deceived her. She claims
Amber.
that, yeah.
Yes, she did not know. She did not know that I was married. That is correct. And, so I'm glad she came forward. I informed her that I am married, and of Lacey's disappearance shortly after, Christmas Eve. It was a couple of days after Christmas Eve. I don't know the exact date.
All right. So curious if anybody had ever spoken on the fact that the plan was to, in order to keep the media engaged in this case, is to do what they all agreed to do as a family. He would stay out of the media, and they would want, they'd be eager to be getting pictures of him, talk to him, stuff like that, keep him, talking about the case. And then it just got to the point that, okay, you guys aren't doing this. You guys are literally just stacking up so many cameras around. Wait till you guys see these pictures when we get into that stuff. So I wanted you guys to hear that part, though, because I thought that was interesting. And the family would know if that truly was a plan or not. So here we go. Claim 11. And this is going to kick off episode 3. And claim 11 is due process. The prosecution suppressed exculpatory evidence in violation of Brady. The prosecution suppressed evidence favorable to the petitioner when it destroyed the physical evidence addressed in claims 7, 8, and 9. Intentionally failed to collect exculpatory evidence as addressed in claim 10, and further suppressed 1, the MPD's investigation into CDCR Lieutenant Appine's report and inmate Sean Tenbrick's discussed while on a recorded phone call with his brother Adam that Lacey saw Todd committing the burglary. This was in those 911 calls, or not 911 calls, but in the recorded jail calls. 2, the fact that the detective Stott lied about verifying the alibis of Todd and Pierce, and that he in fact failed to investigate their alibis before clearing them of any involvement in Lacey's disappearance. 3, the interviews with Susan and Stephen. So Susan Medina, where's her interview? Stephen Todd, during which it was discussed that Todd used the Medina's home phone to make phone calls to his associates during the burglary. How the hell? I know this case pretty much, I think, inside out. Holy shit. Talk about kind of smart back in the day. Again, the people that burglarized the house, they used the home phone line, okay, during the commission to call associates. This information was suppressed from the defense. They had no idea about any of this. Obviously, they would have showed December 24th, not the 26th, and it would have given a time. 4 was MPD's complete investigation into the orange van fire that happened on December 25th, the morning of. 5 is MPD's 2003 investigation into the watch pawned by Renfro on December 31st. 6 is MPD's interviews with James Romano that law enforcement conducted while petitioner's trial was underway, beginning in the summer of 2004. 7 was Detective Grogan and Detective Brochini's suppression of evidence showing that Lacey visited petitioner's warehouse where the boat was stored after the Petersons bought the boat. 8 is MPD's interview with Susan and Rudy Medina, during which the Medinas explained to the police that the burglary had to have occurred on December 24th based on their outgoing mail situation. New evidence, including trial prosecutor Bridget, her sworn 2023 deposition testimony in the case involving Frank Carson and his co-defendants. It reveals that the SCDAO had a long-standing practice of suppressing exculpatory evidence in serious felony cases, including special circumstance cases, including recorded witness interviews with critical material witnesses in violation of Brady. Here, the prosecution systematically suppressed and destroyed virtually every shred of exculpatory evidence known to the police and which the defense needed to support its third-party culpability defense at trial. That misconduct violated petitioner's constitutional right to due process and a fair trial. As a result, the defendant was unable to show the jury at trial that these crimes were committed by someone other than the petitioner. Claim 12, prosecutorial misconduct. The prosecution presented false arguments to the jury. This to me is absolutely sick. I can't even. Every aspect of the prosecution's theory as to how the crimes in this case were committed has now been shown to be false. The new evidence set forth in this petition shows that the prosecution's entire theory of this case was wrong. Literally wrong. Every part of it. But why? How? How did this happen? As such, the prosecution's entire closing argument was false. Unsupported by the evidence as it is now known and prejudicial to the petitioner. In this 659 pages, which I've broken down into 100 page segments so I can easily flip, I'm going to list here this graph / text box. These are the things that were said in the closing arguments. Okay. When you hear people say that they've ever objected during a closing argument, it's because you cannot say things that the evidence did not support. Here we go. Petitioner, quote unquote, strangled or smothered Lacey Peterson the night of December 23rd or in the morning while she was getting dressed, end quote. That is absolutely false. And there was no evidence supporting that. Petitioner, quote unquote, wrapped Lacey up in that blue tarp, end quote. Petitioner backed up his truck to the gate and carries Lacey out. He puts her in the back of the truck. He loads Lacey into his truck, end quote. Petitioner snaps the leash on the dog and he leaves the gate open and he drives away to his warehouse, opens up the door, backs his truck into that open space, unloads Lacey into the boat. He shuts the door, end quote. Petitioner attaches the weights to her and then he puts that cover on the boat, straps it down, and he drives off to the bay. Petitioner backed his boat down in the trailer. He's got the cover on. He goes and puts the truck away. He takes the cover off the boat and stuffs it around her body. Petitioner motored out to Brooks Island. He dumped Lacey out. In addition, with respect to the prosecution's argument that the petitioner used the boat cover to hide his wife's body while driving to the marina, that damning argument misrepresented the evidence at trial and was highly prejudicial to the petitioner. There was no evidence showing that that boat cover had ever been used at all. In fact, so we have the Innocence Project, the Los Angeles Innocence Project. In 2023, counsel the Innocence Project in 2023, they visited the courthouse exhibit room to examine and photograph the condition of the boat cover. As the photographs below illustrate, the nylon ties, I don't know if you guys ever have, I have a boat, if you guys ever had jet skis, and you go to try to strap stuff down and wrap stuff up and it's being drove, when you're going 60, 70 on the freeway, and you're asking that stuff to hold down and it tugs on it and then it starts fraying your stuff. You know what I'm talking about. Ready? As the photographs here below illustrate, the nylon ties on the boat cover are in mint condition, apparently never used, with no signs of use such as stretching, twisting, fraying, any signs of wear and tear. The nylon loops that would have been used to secure the boat cover to the boat remain in pristine condition and do not appear to have been used at all. And again, here are all the pictures that they take out of evidence from 2003 when the case went to trial. And they take the pictures in 2023 to use for this big writ. So they appear to not be used at all. They certainly do not reflect the wear and tear they would have sustained if they were holding the boat down during a 90-mile drive from Modesto to Berkeley, driving at highway speeds. There are also no bungee cords, motherfuckers. How do you have a cover? Great, awesome. What kind of straps do you have? What kind of straps? You have to have straps. Otherwise, boop, it's flying right off in a second. There were also no bungee cords found anywhere during the searches of petitioner's home and warehouse that were suitable for the use with the boat cover. Because remember, what they're saying is that he drove out there, Lacey's body's in there, he had the boat cover on, and that's how he was transporting Lacey's body. In addition, the boat cover was forensically and exhaustively tested, and there was no evidence found that the cover had been stuffed around Lacey's dead body. 169 sample cuttings from the stains that were observed on the boat cover were forensically examined for the presence of blood, urine, feces, and no evidence was found linking Lacey Peterson or anyone else to that boat cover. I call them boom. That's a boom. 169 samples of that boat cover. What dipshits. In fact, when they show the diagram here of all the places that they cut all this stuff out of the boat cover. Oopsies. The prosecution misrepresentation of the boat cover evidence violated petitioner's right to due process and was one more instance of many violations that denied him a fair trial. The prosecution similarly misrepresented the evidence related to the pants. Now, this is mind-blowing. Ready for the pants? Lacey's pants? Whew, here we go. The prosecution similarly misrepresented the evidence related to the pants Lacey was wearing when her remains were recovered. Desperate to shore up its weak and circumstantial case, the prosecution told the jury in the opening statement that the khaki pants Lacey wore to her sister Amy's hair salon on December 23rd were the same pants that were found on her body when her remains were recovered. In quotes, "You're going to hear that her body was recovered on April 14th wearing khaki-colored pants," end quote. Amy Rocha said that when Lacey Peterson was last seen on December 23rd, she was wearing that black jacket, that cream-colored scarf, those khaki pants, end quote. This is what they were saying in opening. That argument was damning because it supported the prosecution's initial theory that Lacey was killed on December 23rd. But that argument was demonstrably false, as it misrepresented the evidence at trial. The prosecution knew that Amy had searched Lacey's closet and located and identified the outfit Lacey wore to Amy's salon on December 23rd, like way previously, like when Lacey was missing, like that day, that night, that next day. Amy Rocha had already found in Lacey's closet and clothes hamper the whole outfit Lacey had worn on December 23rd before Lacey's remains were recovered. Detective Grogren, the one that was banging the DA, the prosecutor. Detective Grogan nevertheless interviewed Amy again after Lacey's remains were found and asked her to select the pants Lacey was wearing on December 23rd from a pants lineup. You can't make this up. They had a pants lineup. What? A pants lineup? Tell me more. Unbeknownst to Amy, the pants on Lacey's body were in photo number 3. Okay. And here they have a pants lineup. Like, you can't make this shit up. Amy reviewed the pants lineup shown below and told Detective Grogan the pants in photo number 3, the pants found on Lacey's remains, were definitely not the same pants she wore to the salon on December 23rd. She had no idea that the pants Amy had previously identified were not included in the lineup. Holy shit. Y'all, let me just repeat that. The pants Amy had previously identified were not included in the lineup. My comment is, these sick pigs, piggy pig prosecutors. The prosecution nevertheless falsely argued to the jury in closing that Lacey was, quote unquote, was wearing those pants I showed you when her remains were found, referring to the pants Lacey wore when she went to the salon on December 23rd. I said, where is Lacey's mom, man? When you're reading this, like you sat through all of this, you know what's up, right? Like, where's Lacey's parents listening to this shit, right? Detective Grogan invested substantial time and effort trying to establish that the pants were the same so that the prosecution could argue petitioner killed his wife the night of December 23rd. But Detective Grogan's efforts failed because they were not the same pants as Amy Rocha repeatedly told him. Claim 13, cumulative error. In some cases, no one individual error is prejudicial enough to warrant relief. But when there are a number of constitutional or statutory violations, the court will conclude that the errors cumulatively undermine confidence in the conviction and warrant relief. That is certainly the case here. It's like that word totality that the police like to use, the totality of the evidence. Well, the cumulative of the error. Claim 14, actual innocence. You guys understand, I didn't write this. The Los Angeles Innocence Project wrote this 659-page writ. Do you understand that Scott Peterson has hardly put in any paperwork during his 22 years in prison? I didn't realize that. I didn't realize that until we're all going to realize that here really soon when I read this. I've already read this just so you guys know. Actual innocence is claim 14. Petitioner has presented new evidence that undermines the prosecution's entire circumstantial case against him and supports his claim of innocence. New scientific and medical research published in peer-reviewed medical journals establishes that Lacey and Connor were not killed on December 23rd or 24th, but were alive until at least December 28th and were most likely killed on January 1st, 2003. Days after Lacey was abducted at a time petitioner could not possibly have been responsible for their deaths. This new scientific evidence further shows that Lacey's body was not put into the bay where petitioner fished as the jury was told, but was instead put into the bay in the waters around the Albany bulb. Dr. Chang's opinion and testimony, which the jury relied on, are not supported by Fane's state-of-the-art 3D modeling. In fact, Dr. Chang's opinions are squarely refuted by it. The new evidence presented in claims 1 and 2 undermines the damning but false testimony by Eloise Anderson, who told the jury her scent dog picked up Lacey's scent at Berkeley Marina on the morning of December 28th, a date Lacey was likely still alive. New evidence presented in claim 4 exonerates petitioner because it shows that Lacey saw and confronted the Medina burglars on December 24th, after petitioner had left home for the day, meaning that he could not possibly have killed his wife and unborn son. New evidence also now connects these burglars to the orange van that was intentionally set on fire in the airport district, that's just the name of the area, the morning after Lacey was reportedly missing. New evidence presented in Claim 5 shows that Detective Brogan and Detective Brochini both falsely testified at trial that there was no credible sightings of Lacey walking the dog and that the police intentionally failed to interview and investigate exculpatory eyewitnesses who reported seeing Lacey walking the dog on December 24th because their investigation was driven by confirmation bias and tunnel vision. New evidence presented in Claim 6 shows that the prosecution's theory at trial that petitioner secretly bought a fishing boat as part of a plan to murder his wife and unborn son and then put their remains in the bay was nothing more than a hypothesis that the prosecution invented to support its otherwise incredibly weak case against petitioner. And finally, new evidence presented in Claims 7 through 11, which shows that the prosecution systematically suppressed and or destroyed virtually every piece of exculpatory evidence that the defense needed to support its third-party culpability defense at trial. All of this new evidence is more than sufficient to state a prima facie case supporting petitioner's claims, including his claim of actual motherfucking innocence. Now, okay. Now this is the procedural history, which is important to understand to see how this case has progressed. Did he ever take a polygraph? Yes. They didn't record it. Wait till you hear. We're just getting warmed up. Wait till you hear this. Right? I am shocked by all of this. Oh, can't believe nobody's talking about it, but you're not going to find people talking about this. You want to know why? Ooh, daddy. It doesn't fit with mainstream the narrative. Okay. So the petitioner's arrest and arraignment on capital murder charges. That happened on Friday, April 18th, back in 2003. The petitioner was arrested in San Diego County, where he was staying with family. Modesto police personally transported him back to Modesto. Okay. On April 21st, a public defender, Tim Baser, represented petitioner at his arraignment. Petitioner was charged with the capital murder of his wife, Lacey, and their unborn child, Connor, in violation of the penal code. The information added multiple murder special circumstances. So the petitioner had no criminal record. He had never been convicted of a felony or a misdemeanor. Nor had he even ever been arrested. There was no history of violence, domestic violence, nor was there any evidence at all the petitioner had of violent nature. Despite an extensive police investigation into his past, law enforcement found no one who could have taken the stand, and they did not, who had ever even had a physical fight with him. Petitioner's friends and families had never heard him raise his voice. This is why I played this in the beginning. I wanted you to hear his voice. This is how he's always talked his whole entire life. Again, petitioner's friends and family had never even heard him raise his voice with Lacey, let alone do anything that would even remotely be characterized as harming her. Police were unable to determine a time, date, cause, or manner of death for either Lacey or Connor. There was no physical evidence, no murder weapon, and no confession. Nevertheless, petitioner was charged with the capital murders of his wife and child. Now, the defense counsel and pretrial discovery. On Friday, May 2nd, defense attorney in 2003, defense attorney Mark Garrigo substituted in as counsel of record. That same day, Detective Grogan and the SCDAO, and then they had that following Tuesday on May 6th, had that bigger meeting with the key investigators and supervisors in this. And this is when they were discussing the video and audio tapes. In this meeting, and it would be, here's a copy of, let's go like this. They went and found all these clips from everything. Here it is. Meeting on Tuesday, 5/6/2003 at 800 hours. I attended a meeting of the key investigators and supervisors in this case. In attendance at this meeting were Captain Greg, all these names, right? Additionally, Detective George Stout attended the meeting from 10 to 11 to brief investigators on the burglary and investigation of the van initially believed to be associated with the burglary. During the briefing, we initially discussed organization of discovery for video and audio tapes, the physical evidence being examined by the California Department of Justice Laboratory, the disposition of the bodies of the victims, and the search warrant, sealing orders, and following up assignments. That same day, just 15 days after petitioner was arraigned on capital murder charges, MPD marked for disposition the destruction of the Medina's safe that was taken into evidence when Todd and Pierce were arrested, and 2 videotaped interviews Officer Hicks conducted with Todd and Pierce at the police station on January 2nd, 2003, the night of their arrest. The very next day, on May 7th, 2003, Modesto Police Department destroyed the January 2nd videotaped interviews of Todd and Pierce. And then the footnote here, 21. The exculpatory value of the January 2nd videotaped interviews with Todd and Pierce was apparent. They memorialized material evidence related to the date that the burglary occurred, the Lacey Peterson missing person investigation, and petitioner's capital murder investigation. Then on May 27th, MPD destroyed the safe, again, before the defense had an opportunity to request it and examine it. The May 6th meeting and the decision by MPD's top brass to begin destroying evidence was consistent with the prosecution's suppression of other exculpatory evidence throughout the pretrial discovery process. Further impeding the defense's ability to investigate the evidence police had collected was the fact that the police reports in the Lacey Peterson missing persons investigation were disorganized. There were no chronological record of the investigation tracking the timeline of investigative steps taken. Can you imagine that there is basically there's nothing that exists in this missing person? She was a missing person. This was not a homicide when they called the police. This was a missing person. Wild. There were no chronological reports of the investigation tracking the timeline of investigative steps taken. Which was not only standard practice in serious felony cases, it is an essential element of any police investigation in serious felony cases. Investigators did not use any type of chronological report to identify tasks and steps taken throughout the investigation. Investigators did not use a clue management system to effectively coordinate efforts and control the volume of information the investigation was receiving, and the investigation did not have clear chain of command, with someone at the management or executive level ensuring that efforts were clearly coordinated and policies and procedures were followed. You know, all of those like tips, where the fuck were they? Where are they? Yes, who else was obsessed with this case back in the day? The net effect of the disorganized and uncoordinated missing persons investigation was that it put the onus on the defense to exercise constant diligence to obtain the pre-trial discovery it was entitled to receive, including all exculpatory evidence which should have been provided without any request by the defense. As one example, on January 17th, 2003, Detective Stogue arranged to have two critical eyewitnesses, Diane Jackson and Kristen Dempworth, hypnotized by law enforcement personnel not legally qualified to conduct those interviews rendering their eyewitness testimony, which was exculpatory, inadmissible at trial. Oh my God. So check this out. You cannot make this shit up. Literally, these two eyewitnesses, they were not able to testify at trial because they went and hypnotized them by law enforcement to see. I cannot believe this. I can't even believe I'm reading this. That eyewitness testimony was exculpatory because both witnesses reported seeing an out-of-place van parked in front of the Medina's home the morning of December 24th. With Miss Jackson describing what appeared to be a burglary in process. They fucking went and did this shit to ruin. These interviews, these hypnosis interviews, were videotaped. Detective Stoughton was presented for both in July of 2003 when defense counsel learned that this even occurred. These hypnotic sessions were videotaped. Counsel requested a copy of the interviews and learned that the videotapes were never booked into evidence. Okay? Because when people mess up with reports, so here it says, here's a Modesto Police Department supplemental report. Narrative. On 7/25/2003, I gave Detective Craig Grogan 2 VCR tapes. Both were taped on January 17th, 2003. The tapes are the interview of Diane Jackson and Kristen Dempelwolf on 1/17/2003. The tapes have been in my custody until now. They didn't even like. Oh God, here we go. Detective Stowe inexplicably was able and failed to book those interviews into evidence, and instead, like Proctor, just kept them in his personal possession for nearly 6 months since January 17th of 2003. From that point, and it says MPD's failure to, this is a footnote, MPD's failure to follow basic standard police procedures and its own policies concerning evidence collection, retention, and preservation in serious felony cases, including high-profile cases, is well documented. In People v. Frank Carson, they bring it up again. For example, the court sanctioned the SCDAO after the prosecution admitted it had suppressed and failed to provide the defense with 82 audio and video files, including exculpatory evidence due to failed systems that were in place in that office. You can't blame the police alone for this. No, I blame the prosecution and the police. Now, it gets better. In the Carson case, audio and video files, which had not been logged into evidence, were found to be located in the personal possession of MPD personnel, including in garages, bags, and computers, where they couldn't crack the code until it was ordered the computers be brought to court. These fucking cocksuckers. Frank Carson and his 4 co-defendants were ultimately acquitted of all charges following an 18-month-long preliminary hearing and a 17-month trial. See also the super at footnote 13, noting that Bridget and Dave Harris, the trial prosecutors at the petitioner's trial, settled a federal lawsuit brought by the plaintiffs Frank Carson and 4 co-defendants alleging malicious prosecution and other claims in the amount of, like I was telling you guys, $22.5 million. One of the largest payouts. Well, get ready to fork over a lot more than that. Now, on August 18th, 2003, in response to the defense's motion for discovery, the prosecution stated, in quotes, "The people have fully complied with the discovery requirements." And so he's arrested in April of 2003. Scott Peterson is arrested in April of 2003. In August 18th, 2003, the people have fully complied with the discovery requirements. In response to the defense's request for exculpatory evidence, the prosecution stated, none known. Footnote here. The defense encountered numerous challenges in obtaining pretrial discovery from the prosecution, which required constant vigilance on the part of the defense counsel when reports were received that referenced audio or videotaped interviews that were not included in the discovery. Pavlik, who was Scott Peterson's defense counsel, would have to send multiple follow-up requests for that additional discovery. Despite the defense's best efforts, critical evidence was still suppressed, which in some cases was not discovered until the middle of trial. And so that was a declaration given by Mark Garagos for this. Now, on August 27th, 2003, defense consultant William Pavlik discovered that the DOJ polygrapher, Janine Overall, had videotaped the polygraph interview she conducted with Todd and Pierce on January 3rd, 2003. Her report omitted the fact that the interviews were recorded. They have everybody in there fudging fucking reports in this. It's like, this is like Norfolk County, but even I think worse. Okay. They have everybody fudging reports for them. Now, Pavlik sent an email to the prosecution stating both burglars were polygraphed, audio taped and videotaped. We need the audio and videotapes from these interviews, especially the polygraph interview, so they could be compared to written reports. On September 10th, 2003, on the eve of the petitioner's preliminary hearing, so remember I told you Scott Peterson was not indicted by a grand jury. And the ham sandwich can be indicted, okay? Scott Peterson was not indicted by a grand jury. He had a preliminary hearing, okay? So, once again, Detective Stout admitted that he had not checked the January 3rd, 2003 videotape polygraph interview into evidence, meaning there was no record of them in MPD's evidence and property reports, EPRs. Instead, Detective Stout stored the videotape interviews of Todd and Pierce in an unknown secure area for 9 months. I said, oh my God. The Detective Scultery booked the two videotaped into evidence on September 10th, over 9 months after the interviews were completed. Now, footnotes here. Overall, asked Todd other relevant questions related to Lacey's disappearance, which she did not include in her written report, as questions for which Todd showed no specific reactions indicative of deception. The obvious and reasonable inference is that Todd did not pass with respect to the other questions excluded from Overall's report because he did, in fact, have information about Lacey's disappearance. She just didn't even write it in there that she asked all these questions. They were trying to act like they weren't even asking these people who they said the burglars had nothing to do and it happened on the 26th. Then why the fuck are you even asking them any questions about Lacey Peterson if the burglary didn't happen until December 26th? Capiche? The defense did not discover that Overall's written report contained certain critical omissions regarding Todd's performance during the polygraph examinations, likely because the quality of the audio taped interview was extremely poor. The Los Angeles Innocence Project dedicated considerable resources and consulted with forensic experts to improve the quality of the audio so the questions asked and answered given during Todd's interview could be fucking deciphered and transcribed. Not until 6 weeks after petitioner's preliminary hearing was over, and a month after he had been bound over for trial on December 30th, 2003, did the prosecution provide the defense with a 2-page report buried within about 5,000 pages of discovery, stating that Detective Stout had stored the polygraph interview tapes in an undisclosed secure area for 9 months. Now, on September 14th, 2003, Pavlik emailed a second time confirming receipts of the polygraph tapes, but asking for an audio copy of Todd's interview. In this email, Pavlik also renews his request for the January 2nd videotapes generated by Officer Hicks, referenced in Hicks' report. MPD's general orders in place at the time require that all evidence be checked into the evidence property room no later than the end of the shift during which it was collected. Petitioner received a replacement copy of Todd's January 3rd, 2003 polygraph interview on September 24th, 2003. The prosecution ignored the request for January 2nd, 2003 videotapes or the destruction orders and instead informed Pavlik that, per the directions of DDAs Harris and your emails to this office will now be blocked. Discovery violations continued to reoccur, including throughout the trial and thereafter. Now we get to the preliminary hearing. So he has his preliminary hearing on October 29th, 2003. Petitioner's preliminary hearing began before Judge Girolami, something like that. Girolami, probably. It concluded, so it starts on October 29th. A preliminary hearing. Brian Koberger's preliminary hearing was set for a week. Scott Peterson's preliminary hearing started on October 29th and it concluded on November 18th. So do the math. 20 days. 20 days. And on December 3rd, the petitioner was bound over for trial because he took all of it under advisement. It wasn't like that day. Okay, yep. No. December 3rd, petitioner was bound over for trial. After that preliminary hearing, the prosecution produced a number of police reports in discovery that were created months earlier, but not given to the defense until after the petitioner was bound over for trial. In addition, there was a clear pattern of investigators failing to follow the MPD's own reporting policies requiring that reports be reviewed and approved by a supervisor and be filed no later than the end of the shift. 2, that evidence collected be booked into MPD's evidence and property room no later by the end of the shift during which it was collected. Throughout the investigation, this is a footer, pre-trial and trial proceedings, tabloids and other media outlets were publishing information leaked by law enforcement and other unknown individuals. The defense argued that the MPD and Detective Brocheni in particular was using the media to put increased pressure on petitioner to confess. The defense argued, for example, that in January of 2003, Detective Brocheni leaked false information to the Modesto Bee that, quote unquote, Scott had just taken out a $250,000 life insurance policy on Lacey, which the Modesto Bee puts it into a headline in the paper. That morning, when the headline reads financial motive and insurance policy purchase, Brocheni at 6 a.m. calls up Scott's friends and says, go read the Modesto Bee. Go read the Modesto Bee. I want to see that. They didn't stop there. They absolutely told or put out information that was patently false. They wanted a confession because they had no evidence. Brocheni admitted that he called Scott's friends early in the morning on January 17, 2003, and told them to read the Modesto Bee article, which he knew contained false information about Scott purportedly taking out a life insurance policy on Lacey just prior to her death. Detective Brocheni knew the information was false because on January 5th, 2003, he interviewed the insurance agent who sold the fucking Petersons their policy and learned that the policy was taken out in 2001 when the Petersons bought their home in 2001, which was in April. Scott and Lacey each purchased a policy for $250,000. They both had one. In January of 2004, Scott Peterson moved to petitioner motion to dismiss. It was denied. Okay. Then the defense motioned for a change of venue. The media attention and coverage of this court proceeding in this case was at a fever pitch long before the preliminary hearing even started. Of the first 4,000 pages of the clerk's transcripts in this case, close to half concern media requests to access the sealed court records and other investigative materials. The judge that experienced this whole thing was presiding over the pretrial hearings observed in my over 30 years in this community, I've never seen anything like the publicity generated by this case. If you guys see these pictures and you guys can remember, I'm going to try to go find some stuff. I'm going to show you guys. It is absolutely crazy. What they allowed. Okay. They allowed the Peterson's street that they lived on. It was just blocked off so that all the media could just take over the street. How the fuck is that allowed? How is that not a safety issue? No, Modesto police, they wanted this. They wanted this. General orders require completed police reports to be submitted by the end of the shift in which the report was assigned and reviewed and approved by a supervisor, but numerous reports were not prepared by the end of the shift. In some cases, reports were not prepared until days, weeks, or months after the event being reported occurred. The majority of police reports generated in this case were not approved by a supervisor. As just one, Detective Grogan appears to have signed off on his own fucking report detailing his investigation into the pawn slip he located for the watch. What a piece of shit. You know who Grogan is. Fucking the DA, fucking the prosecutor. Now, a local reporter who was closely covering the case at the time, Gloria Gomez, admitted in 2017 interview, finally, Gloria, you got some fucking, a conscience? She admitted and said that the police leaked information to her during the investigation. I want to know if Brian Etton's ever going to say that. I want to know if Ashley Banfield's ever going to say that. Okay. The police leaked information to her during the investigation. And she said this at they found it. They got the exhibit here. The Murder of Lacey Peterson, Season 1, Episode 2, Media Frenzy. Shireen Anderson and Poe Cutchins. And they give the timestamps. Gomez stated that investigators, quote unquote, did share a lot with her as far as what was going on behind the scenes, end quote. And that she learned early about pieces of evidence, including the bleach. Ready for this? The reference to bleach. So everybody that talk about this Scott Peterson case, if I hear one more motherfucking person say that there was bleach in that house and used to clean up, you need to shut your fucking mouth. Okay? There is no bleach. There's never been bleach. Here it is for the record. I'm stating it one last time about bleach. The reference to the bleach concerns false reports that circulated widely in the media about police purportedly noticing that the kitchen floor was wet and that the Petersons' home smelled of bleach when police arrived around 6:30 p.m. on December 24th to search the house. See Larry King Live, Nancy Grace, you son of a bitch, guest host, quote unquote, Peterson's hearing, day 3, aired October 31st, 2003. Laura Ingle, there was a stench of bleach in the front part of the house when police detectives arrived, end quote. Judge Janine Perro, in quotes, if the police are there on December 24th and the cleaning with bleach was in a back room on the 23rd, then why do we so smell much of it? When the defense accused Detective Broceni of leaking the false information about the Petersons' house smelling of bleach, the SCSC Judge Loretta Bagan was interviewed by an investigator from the SCDAO, and she stated that Detective Broceni met with her on the evening of December 31st, 2002, or on January 1st, she couldn't remember, so she could review a search warrant on an unrelated homicide. Judge Bagan stated that she believes she heard Detective Broceni mention, in quotes, that he smelled the odor of bleach or someone told him they smelled bleach on the Petersons' at the Petersons' residence. Detective Broceni admitted he talked to Judge Bagan about the mop and the bucket outside of the Peterson's residence, but he denied telling her he had smelled bleach. It was conclusively established through the testimony of the responding officers that there was, in fact, no odor of bleach in the Petersons' home when they arrived and searched the home the night of December 24th, 2002. Nancy Grace, fuck you, bitch. Your name is in here and I fucking love it. You are sick, Nancy Grace. You need help. I love it. The fact that Nancy Grace, how does this 569-page filing make you feel? She has a 700,000 person platform. House didn't smell like bleach. Okay. Guess what? They didn't even have bleach in that motherfucker. In addition to all this crap, Pin Kai, criminalist for the California Department of Justice at the Ripon Lab, analyzed both mops and the mop bucket and determined that they smelled of common household detergents used to clean floors, not bleach or chlorine. She did not find any blood, tissue, or other incriminating trace evidence indicating they were used to clean up any type of a crime scene. God. And yet, the false information about the bleach that was leaked by law enforcement to Gloria Gomez and fucking Nancy, and the false information about the Petersons' insurance policies that was leaked to the Modesto Bee, just two known examples just of the misinformation intentionally leaked to the media, continued to permeate the media coverage of the court proceedings in this case and caused petitioner substantial prejudice. He was convicted by the media long before his trial ever began. And that's a fact. And everybody that ever will come into my lives and say he's so guilty, take the link and tell me that you know anything about the case. Because I know that you don't, because this case was never televised, and I know that you don't read documents. But you'll read the fucking nasty ass Inquirer. The media and tabloids continued publishing articles that contained false information throughout the trial. There are 74 references to the National Enquirer alone in the trial transcripts. As a result, the defense was required to dedicate significant resources that should have been spent preparing for trial to responding to filings by the media, who were requesting access to sealed documents, as well as permission to televise and photograph courtroom proceedings. There were hundreds, if not thousands, of pages of media requests filed with the court seeking additional access to the proceedings even before the trial began. On January 8th, 2004, the court heard argument regarding petitioner's request for a change of venue due to extensive media coverage effect on jury pool. On January 20th, 2004, the court granted petitioner's request. It denied the request to change venue to Los Angeles County, Orange County, or Almond County, but granted the petitioner's request for venue to be in San Mateo County. On February 2nd, 2004, San Mateo County Superior Court Judge Alfred DeLucci began presiding over the pretrial matters. On the court's own motion, on February 9th, 2004, Judge DeLucci struck the second multiple murder special circumstance allegation from count 2. Judge DeLucci, who was also a respected veteran jurist, commented on the unprecedented media coverage in the following. This case has generated a great deal of media coverage to date, probably more than any other case in California in recent history. And I include, I think, even Manson and O.J. Simpson. This case has been on the media and it's been in the news day after day after day after day after day since its inception back in 2003. From February 11th through the 17th of 2004, Judge DeLucci held a Kelly Fry hearing on the admissibility of GPS tracking device evidence police gathered from petitioner's vehicles during the months Lacey was missing, which the prosecution sought to use at trial as evidence of his guilt. This should have never been allowed. The court allowed the GPS evidence, but ordered the prosecution over its objection to disclose to the defense where the devices were placed on petitioner's vehicle. Who gives a fuck where they were placed? This surveillance and GPS evidence at trial did not implicate petitioner in the murder of his wife. it showed that he went to the Berkeley Marina beginning on January 5th, 6th, 9th, 26th, and 27th, initially to search for witnesses who could confirm his alibi, since MPD claimed it could not verify his alibi, even though he gave police a date and a timestamp receipt that night, showing exactly when he was at the Berkeley Marina on December 24th. Can you believe this? They were saying that he was going there just to, let me go just check, make sure their bodies aren't, coming up. Oh, is that right? This is just absolutely crazy. This is wild. I want to tell you guys about this jury, some of this jury stuff. Jury selection. Jury voir dire began in San Mateo County on March 4th, 2004. How could this fucker go to trial so quickly? Scott Peterson's court case went to trial. Like, they did jury voir dire March 4th, 2004. The parties agreed on a jury questionnaire after nearly 1,000 jurors completed their questionnaire. That showed that 96% of the potential jurors had been exposed to publicity about the case and of the group. 45% were willing to admit that they had prejudice already against Mr. Peterson's guilt. On May 3rd, 2004, the defense counsel filed a second motion to change venue based upon the pretrial publicity in light of the information contained in the juror questionnaires. The prosecution objected once again. This time, the trial court denied the motion to change venue, noting that the publicity in this case had been nationwide and that the change of venue is useless if the publicity has been nationwide, citing that you'd have to move this case in quotes to Mars. Opening statements in the guilt phase began on June 1st, 2004. He was arrested in April of 2003. Oh, Joshua, you're so wrong. I'll be any amount of money on this. He's guilty. Sorry, Lana. I appreciate your efforts, but he's a scumbag. Joshua, you need to hear this. I promise. There's only a couple scumbags, okay? And they're right here in this document. Now, again, opening statements in the guilt phase began on June 1st. The state rested its case in chief. The state rested October 5th. The defense rested its case on October 26th. And I'm over here thinking, who the hell were you calling if you weren't calling experts, The jury began deliberations on November 3rd. So, again, if the defense rested on the 26th, why is the jury deliberating on the 3rd? How long was closings? What the hell's going on here, right? Now, listen to this deliberating. Listen to this mess, okay? Now, the jury deliberated on all day on November 4th, but I thought that you said that the jury began deliberating on the 3rd, so they began at some point on the 3rd. Then the jury took all day on the 4th, returning with a request to examine exhibits. The jury then deliberated all day on the 5th, returning with a request to see additional exhibits. The jury deliberated all day on November 8th because I bet you, I don't know why you wouldn't have, they were off the 6th, 7th. I'm guessing it was a weekend. Then the jury continued deliberating until about noon on November 9th. Then the court then dismissed juror number 7. And it's like, okay, so think about this. You just had your part of the 3rd, then all day on the 4th, all day on the 5th, all day on the 8th, and then noon, so half a day on the 9th. So you're at 4.5 days, and then they boot a juror. Okay, which means you have to start all over once you then get a new juror. So deliberations began anew that afternoon, November 9th. This second jury deliberated that afternoon, and then the next day until juror number 5 was discharged late the next morning. On November 10th, then, the third reconstructed here jury, because you have to get then another person, they then began deliberating. This third jury deliberated the remainder of the 10th. On the next day of deliberations was November 12th. The jury found Peterson guilty. you have to start all over from the beginning when you have somebody that leaves and comes in. And when I read that, I had no idea that that took place. And if I did at one point, I forgot it. Okay. Those people wanted to leave. That's what this tells me. And they're pointing it out to say, if you have to start back from the beginning, which is pretty hard because you're trying to remember, like, everybody else knows some stuff, you know, you have to go back. So can you believe that? How can this juror be brought up to speed and know everything that these other people would know? That's just, anyways. Then you have the trial penalty phase, which was November 30th. Then the defense motion for a new trial on February 25th, 2005. Petitioner filed a motion for a new trial based in part on newly discovered evidence showing that the MPD investigated information provided by the CDCR. You know, it was Lacey seeing Stephen Todd breaking into the home on December 24th and failed to provide the defense with any of that police report documenting that investigation, which is true. That happened. And finally, the defense gets that information here. Scott gets that all here in 2025 with people coming forward and saying that I'll fill out a declaration. In December of 2004, after petitioner had already been convicted, defense investigator Carl Jensen interviewed Lieutenant Aptone, who stated that he informed MPD in January of 2003 that he had in his possession a recorded call between the two inmates, wherein Adam stated that Lacey saw Todd breaking into the house. Do you know how strong that is? Because these inmates were talking, they're brothers, and they were talking to their sister outside on the outside. Petitioners submitted a statement by Lieutenant Aptone indicating that MPD investigated that exculpatory evidence. MPD Detective Craig Grogan, you know, the pounder who's having sex with the prosecutor, filed an affidavit stating that he found no record of MPD reviewing or receiving, rather, the audio tape from the audio call from Lieutenant Aptone, and that no one at MPD admitted to interviewing Sean Tenbrick when Detective Grogan sent an email to detectives, officers, and supervisors involved in the Peterson case at MPD asking for information about the interview. Now, on March 16, 2005, the trial court denied the petitioner's motion for this new trial on the following grounds: that Lieutenant Aptone's exculpatory evidence that Lacey saw the burglary happening was not newly discovered. Even if it was newly discovered, it was not worthy of belief because it came from an inmate. Oh my God. Oh my God. Dude, this is a recorded call. This isn't like Scott Peterson going and hitting people up. Like, what? Wait. Now inmates aren't reliable, but we're using them as jail rat snitches and shit like that. You gotta be kidding me. Oh my God. Even if it was newly discovered, it's not worthy of belief because it came from an inmate. And the court was not too impressed by evidence connecting Lacey's disappearance to the Medina burglary because Lacey Peterson, under one interpretation of the evidence, was already missing by the time the burglary took place. The trial court's ruling missed the point entirely. This is a footer. Again, this is the Innocence Project writing this. The suppressed exculpatory evidence was not the tip sheet showing Lieutenant Aptone had called MPD, which the defense was provided. The suppressed exculpatory evidence was MPD's entire investigation into Lieutenant Aptone's tip, including interviews with him, Lieutenant Aptone himself, as well as Sean Tenbrick, which Lieutenant Aptone stated MPD undertook, but which Detective Grogan claims did not occur. The failure by law enforcement to document and provide the defense with the information gathered from its investigation into what Lieutenant Aptone's report and the apparent failure to follow up on that information is a serious breach of police procedures and a violation of MPD's constitutional and ethical duty to comply with Brady, bitches. I was like, oh my God, what? I just love it. Now, the next thing that would occur here is the petitioner then appealed his conviction to the California Supreme Court. And so we're going to fast forward all the way to July 8th of 2009. Attorney Cliff Gardner was appointed by the California Supreme Court to represent petitioner. The record on appeal was certified for accuracy not until 2012. So by the time you do it all and get it in. Okay. So he's arrested in 2003. He has his trial in 2004. They put in this direct appeal because of, hey, what I just told you guys. Then on July 8th, 2009, petitioner appealed his conviction to the California Supreme Court. So he gets his representation, and then he files his certificate for the record for the brief in 2012. On July 5th, 2012, petitioner filed his opening brief raising 16 issues on appeal, including 9 claims of error related to jury selection, jury veneer, and jury instructions, 4 evidentiary issues, and 3 issues specific to the death penalty phase of trial. On August 24th, 2020, the California Supreme Court issued its opinion on the direct appeal. What? Motherfucker put this shit in 2012? On August 24th, 2020, the California Supreme Court issued its opinion on the direct appeal. Do you guys know what a direct appeal is? That's like the direct appeal. That's what you do right after your direct appeal. He was convicted in 2004. He's getting an answer back from the California Supreme Court on his direct appeal in 2020. It issued its opinion on the direct appeal, affirming the judgment as to guilt, but reversing the judgment as to the sentence of death, and remanding the matter to the Superior Court for a new penalty determination. On February 22nd, 2021, the United States Supreme Court denied a petition for certiorari on direct appeal. Now, on remand on the sentencing to the San Mateo County Superior Court, the prosecution initially announced it was going to retry the penalty phase to reimpose the death penalty. However, on May 16th, 2021, the defense sent the prosecution a formal motion for discovery, requesting the production of 22 items of discovery that should have been, but were not provided at the time of trial. A week later, instead of responding to that defense request for those 22 items of discovery, the prosecution announced it would not pursue a retrial of the penalty phase, and instead agreed to accept a life sentence without the possibility of parole for Mr. Peterson. On December 8th, 2021, petitioner was resentenced to life without the possibility of parole because they didn't, oh God, we have to turn over stuff? Oh, no. We'll go with the whole, yeah, he can have life, right? Now, here we are. California Supreme Court, case number, this is for the habeas. On February 18, 2010, Lawrence A. Gibbs was appointed by the California Supreme Court to represent petitioner in his habeas corpus and executive clemency proceedings related to his conviction and sentence of death. On November, then it would be 5 years later, on November 23rd, 2015, petitioner's initial habeas corpus petition and supporting exhibits were filed. Petitioner raised the following issues, and so he goes and lists stuff about a seated juror being biased with voir dire, then ineffective assistance of counsel, failing to consult with and present the testimony of an expert in the field of fetal biometry, violation of the state's introduction of false evidence that a trailing dog Detective Lacey sent at the boat, ineffective assistance of counsel of not getting an expert in the field of dog scent identification, the state's introduction of false evidence that the bodies of Lacey and Connor could only have originated from the area in which petitioner said he was fishing, ineffective assistance of counsel in failing to present the testimony of an expert in the field of movement of bodies in bays, and by counsel's failure to effectively cross-examine the prosecution's expert. Next, ineffective assistance in promising the jury that it would hear 3 categories of exculpatory evidence, which would prove Scott was stone cold innocent, and then by not fulfilling those promises. Petitioner was deprived of all of this stuff for ineffective assistance of counsel and failing to present exculpatory evidence. Petitioner was deprived of all 5th, 6th, 8th, 14th, when his counsel failure to present exculpatory evidence that Stephen Todd saw Lacey in Modesto after Scott left the marina. Cumulative error. And then there's talks about the death penalty. And then, yeah. Now, on March 6th of 2017, Mr. Gibbs was removed, or I'm sorry, he moved to withdraw himself as petitioner's habeas corpus executive clemency attorney. And on July 12th, 2017, so a couple months later, the California Supreme Court granted that motion. That same day, the court appointed Cliff Gardner as lead. Okay. Respondent filed its informal response to the initial petition on August 10, 2017, and petitioner filed his reply to the informal response on August 7, 2018, then a year later. Then here we are on October 14, 2020. The Supreme Court unanimously issued an OSC directing that the Secretary of Department of Corrections and Rehabilitation to show cause in the Superior Court of California why the relief prayed for should not be granted on the grounds that juror number 7 committed procedural misconduct by not disclosing her prior involvement. Remember? Why? What the fuck? The court summarily denied claims 2 through 11 without a reasoned decision, and then denied claims 12 through 19 as moot because it had to do with the death penalty, and they already took that off the table. Now, in 2016, petitioner's habeas counsel at the time made an informal request through the Attorney General's office for a complete file on a December 25th, 2002 vehicle fire. In response, the SCDAO, this is their response, provided an investigative report. The report included never before disclosed items such as the 2003 DOJ testing results of a mattress that appeared to be blood-stained, the identity of the last known driver of the van, and the property reports indicating that some of the evidence associated with the van had been destroyed. It did not contain any photos of the mattress. On July 19, 2016, petitioner's then counsel made a second request specifically for color photos. I cannot believe they had to ask for colored photos. Okay. On October 12, 2016, photos of the bloodstained mattress were disclosed to the petitioner for the first time. In June of 2019, the SCDAO, with the agreement of the Attorney General's office, together with Habeas Corpus Resource Center, who was for counsel for the petitioner at the time, filed a joint stipulation for post-conviction examination of physical evidence in the county superior court. For reasons that are unclear to the Los Angeles Innocence Project, they say this stipulation was severely limited with the testing that was to be performed, and stated that unless the presence of blood and female DNA was found on the fabric, no further testing would be conducted. You know, that juror lied her ass off, by the way, with the question that was asked. And so she lied her ass off, just so you guys know that that's in a footer. I'm not going to even... she fucking blatantly lied about 3 things. Now, on September 20th, 2019, Forensic Analysis Crime Lab, Alan Keel, who conducted the examination of the evidence, issued a report stating that, in quotes, it cannot be determined whether blood is present on the number 1 mattress material or number 2 cloth from the mattress, nor can it be determined whether the trace amounts of the male DNA come from the staining on the fabric specimen, end quote. No further testing was conducted in 2019. The limited testing conducted in 2019 was not designed to gather as much information as possible from the evidence. Now, explain that the presumptive positive test for the blood conducted in 2002 resulted from relatively large sections of the stained fabric being placed into the vial, whereas the testing conducted in 2019, pursuant to the joint stipulation, tested only tiny fragments cut from the fabric. Retesting that subject's larger sample cutting to DNA analysis is a reasonable and clearly distinguishable approach designed to determine if Lacey or Connor's DNA is present on the mattress. Like, who the fuck would ever stipulate to this shit? And so here they're saying, like, this needs to be redone, this part. Now, the juror misconduct evidentiary hearing that took place that we all knew about, that takes place in 2020, okay? And the case was remanded to the San Mateo County Superior Court. And on December 11th in 2020, the respondent filed a return to the petitioner. In its return, respondent provided the documentation showing that in November of 2001, the juror number 7's boyfriend was charged with domestic violence against juror number 7 and pled no contest to the battery. Information juror number 7 failed to include in her questionnaire answers. Because the prosecution's case against petitioner necessarily involved domestic violence, and juror number 7 had not disclosed her own domestic violence incident to response to question 74, asking if she had ever been the victim of a crime, petitioner made additional factual allegations in his denial to the return, which he filed in June of 2021. Ultimately, they basically say he didn't suffer any fucking prejudice. Okay, great, awesome. If that's what you want to fucking say, go right ahead. Now listen to what Scott Peterson does. Now this is mind-blowing for me. That denial came on December 20th, 2022, by the way, when the Superior Court issued an order denying relief as to claim one of petitioner's initial petition, which was the juror. Scott Peterson then, on April 19th of 2023, who was by then without counsel, filed a pro se petition for writ of habeas corpus in the Court of Appeal, First Appellate District, within 120 days of the date the Superior Court denied his relief. He did it himself. Petitioner requested appointment of counsel to further develop the allegations in the pro se petition and an opportunity to seek funding to secure additional investigative and expert assistance as necessary to prove the allegations in the pro se petition related to he was talking about the fetal biometry. So he knew that he could ask the court, listen, I need you to appoint me. I need funding. I need money for this. And I need a court appointed attorney because I cannot do this. This is going to require X, Y, and Z. And he wasn't lazy and he did it. On April 27, 2023, the Court of Appeals directed the Attorney General to file an informal response to all issues raised in his petition within 30 days. They asked for 2 extensions. On June 12, 2023, petitioner filed a declaration of indigency in support of his request for the appointment of counsel, asserting that his petition includes scientific evidence claims which needs professional assistance to be developed and that he is not permitted access to the voluminous discovery he needs to litigate the claims in his petition, including evidence in multimedia formats while he is in prison. On July 25, 2023, the Attorney General filed an oversized informal response with exhibits asserting that all of petitioner's claims were without merit or procedurally barred or both. They were wrong. On July 28, 2023, the Court of Appeal granted the Attorney General's request to file an oversized informal response and granted petitioner's request for appointment of counsel. On August 3, 2023, the Court of Appeal appointed Corey Franteno to represent petitioner on an independent basis and ordered petitioner to file a reply to the Attorney General's informal opposition within 60 days. Well, then Scott Peterson's guy asks for an extension. Then, lo and behold, whoever got this for him, whoever sent this for him, on November 6th, 2023, the Los Angeles Innocence Project post-conviction investigation began, and they took over the case. November 6th of 2023. Everything that they did began literally 1 month they had, or 2 months. It was all around the holidays, so basically wipe out November and December. All of 2024. And then basically half of 2025. This fucker was filed August of 2025. What they were able to do from the time of taking this on is nothing short of a fucking miracle. I'm not even playing. Like, holy shit. Now, don't get me wrong. A lot of people leading up to that, like I said, the guy who wrote the book that was his old attorney, whatever he was, he did phenomenal work. I think Scott Peterson did a lot of work. And so here we are sitting here with this document. And I just think that so much, like, people want to say whatever about this man. Okay, he was cheating on Lacey. He's a, like, fuck y'all, look at Karen Reed like she's a goddamn saint. All right. Karen Reed would be in prison right now if she did not have the experts that she had in that case. She goes to prison. And everybody would think that she's a, whatever, kissing on Higgins and doing, playing stupid games and whatever. Not to mention a murderer. He put together and filed 120-page declaration himself. Scott Peterson did. Now listen to what happens here. So, Innocence Project is like, okay, we're going to get down and let's go to town. So the Innocence Project, the petitioner's informal request for discovery of and request to meet and confer with the SCDAO. So were the prosecutors were that ran this case. On November 14th, 2023, Los Angeles Innocence Project Council sent a letter to the SCDA district attorney Jeff Leggero, requesting informal post-conviction discovery pursuant to Penal Code section blah, 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 and to meet and confer to discuss additional DNA testing of evidence in this case. The DA responded by stating that the original trial prosecutors in this case, Bridget Flatiger and Dave Harris, remain the prosecutors handling the Peterson matter, in quotes. And that they, in quotes, will continue to be the point of contact on this case. Okay. Modesto police officer John Evers was a named defendant in the matter of that big old case with Frank Carson. Mr. Evers testified under oath that DAs Bridget and Dave Harris were involved in the investigatory briefing in the Scott Peterson case. Do you know what that means? Oh my God. So, coming off of fucking hot 22.5 mil they got popped and hit with. These pieces of shit were involved in the investigatory. So Mr. Evers testified under oath that DAs Bridget and Harris were involved in the investigatory briefing in the Scott Peterson case. Counsel responded to DA his decision to have the original trial prosecutors remain the prosecutors handling the Peterson matter, and asked him to reconsider that decision because it is no longer considered best practices to have the original trial prosecutors reviewing their own convictions, which they are heavily invested in defending, particularly where there are allegations of prosecutorial misconduct and a claim of innocence, as there are in this case. The DA did not reply to counsel's request. On December 14th, 2023, Special Prosecutor Bridget over here, responded to petitioner's informal request for discovery, stating that there is no informal discovery process provided under that code, but agreed to meet and confer once the new year approached. So, on January 17th, 2024, petitioner filed 2 post-conviction motions in the San Mateo County Superior Court, a motion for DNA testing pursuant to this, and a motion for post-conviction discovery pursuant to this. On January 22nd, 2024, the Deputy Court Executive Officer informed the parties petitioner's motions were filed in the wrong, they're not in the correct venue, and should have been filed in SC Superior Court, where, the cheaters are. That same day, counsel provided legal authorities explaining that the venue is proper in San Mateo County and that the prosecution occurred with counsel's assessment the following day. On February 13th, 2024, counsel attended an in-person meeting to confer. Here we go. Let's meet these motherfuckers. So we're going to meet Special Prosecutor Bridget, who was getting plowed by the police officer detective dude. Remember? She's the hoe, leg spreader. And Harris. So they all meet. At which time counsel learned that the SCDAO would oppose both post-conviction motions and would not stipulate to any of the DNA testing that the petitioner requested in his motion. On February 20th, 2024, the deputy court executive officer informed the parties that, you know what, the court had researched the issue and determined that, yeah, San Mateo County was the proper venue for petitioner's post-conviction motions and that the matter was being assigned to Judge Elizabeth Hill. Okay. Here we go. With the SCDAO refusing to provide any of the requested post-conviction discovery informally on February 24, 2024, counsel sent a CPRA, which is basically like a FOIA request. Okay, CPRA. Request to the SCDAO custodian of records seeking public records. Here's a footer. Counsel requested records it has received from other counties by way of a CPRA requests, including records related to the district attorney's office policies, procedures, training material concerning discovery compliance, including disclosure of Brady materials, everything that I do, FOIAs basically. So on March 5th, Special Prosecutor, leg spreader, Bridget, not the SCDAO custodian of records, but Bridget, she denied counsel's CPRA request as unduly burdensome, protected by privilege, confidential, and not in the public interest to disclose, and not subject to disclosure because petitioner was seeking similar materials by way of his post-conviction discovery motion, which the SCDAO stated it would oppose. Footer. The fact that Miss Flatiger, who's Bridget, was apparently acting as a gatekeeper for petitioner's CPRA requests rather than the SCDAO's custodian of records is an actual or perceived conflict of interest, especially where prosecutorial misconduct is at issue. In addition, LAIP, which is the Los Angeles Innocence Project, informed the DA, Ligario, on November 14th, 2023, that a witness had come forward with information suggesting that Ms. Flatiger had a personal relationship at the time of trial with MPD lead investigator Detective Craig Grogan. This is where I found out that she's a leg spreader and that she was fucking the lead investigator. This prosecutor. Just getting plowed. Okay. The personal, as I told you, remember November 14th that I had a witness come forward with information suggesting that we have a hoe activity going on. Okay. And a witness, Bridget herself, called to testify on behalf of the prosecution back in the day. The personal relationship was not disclosed to the defense. Neither Miss Bridget Flatiger nor the DA denied or otherwise addressed petitioner's concerns about the allegations that she had a personal relationship with Detective Grogan and therefore a conflict of interest at the time of the trial. Woo-hoo! Joshua, you know it. Sip them back, baby. Listen to this shit. I love it. Oh my God. Just getting tore up. This is amazing, right? So, now, the only document that Miss Bridget provided in the response to the petitioner's request was a document dated March 11, 2011, entitled Brady Process. Well, Miss Bridget's response, while opaque, appears to be an admission that the SCDAO had no Brady policy in place in its office until 2011. She flipped the switch on that shit. Petitioner moved to conduct DNA testing on physical evidence that fell within the three categories, which was 1, physical items collected from the van fire, and 2, physical items of evidence found at or near the recovery sites of Lacey and Connor's remains, including a piece of duct tape, okay, that had duct tape that was adhered to Lacey's pants when her remains were recovered, which was tested in 2003 and shown to have human DNA on it, but from which no genetic profile could be obtained. Items 5 through 12, and items 3 of physical evidence that may have been recovered from the burglary from the home. Now, on May 29th, 2024, after briefing and arguments, oh God, I can't wait till I'm going to rewind this. I want to see who this hoe, what she looks like. Let's go find her. Now that we know the dirt, the tea. So back 29th, 2024, after briefing and argument on petitioner's motion for the DNA testing, Judge Hill granted petitioner's motion for additional DNA testing on the duct tape from Lacey's pants and derivative evidence collected from it in 2004. The swabs, the slides, the slide covers on the ground, the broader sampling with the improved methods, and more sensitive DNA testing may reveal probative results. Well, go give it to author, man. Judge Hill, though, denied petitioner's motion to conduct additional DNA testing on the stained mattress fabric from the van on the ground that he had filed, on the grounds that he had filed to establish that the DNA results would be material to determine the identity of the perpetrator, and failed to show that there was a reasonable probability that Lacey was in that van at some point, because you got to have a nexus there. Well, guess what? That was before they had the newly discovered 2025 information, when all of that was going on. Okay. When petitioner filed his DNA motion, he did not yet have the new evidence set forth herein in Claim 4, showing a direct link between now the Medina burglars, the orange van, and Lacey Peterson confronting them, because that was all suppressed. That evidence was not obtained until January of 2025. Petitioner has now shown that there is a reasonable probability that Lacey Peterson was in that orange motherfucking van. The SCDAO should stipulate that it is in the interest of justice to conduct additional DNA testing on the bloodstained mattress. Who would have any problems with any of this? If you're truly reading this and you're like, yeah, I think that we should. Okay. The prosecution informed the petitioner that MPD failed to collect any of the items Susan Medina pointed out to them that were handled by the burglars, pointing out to the police that certain items were handled by the burglars and should be fingerprinted, and being told by police that she watched too much CSI. The fuck? Bitch, you watched too much CSI. I'm going to tell you what, if a cop ever said that to me, I would say, you don't watch enough. Start getting on my shit here. The reason that she's probably asking for all this shit is because her fucking, neighbor's missing. Over the course of the next 3 months, the parties worked to have the testing conducted by a mutually agreeable independent lab, and I wish we knew what it was. And right now, I've gone through I haven't got to the point that I would know the lab. That testing was completed. The lab report was filed with the San Mateo Superior Court under seal, and the evidence has been returned to SCDAO. Because Judge Hill denied petitioner's request for a complete and current copy of MPD's evidence and property records, EPRs, he has no way of knowing what other items of physical evidence were collected by the police, what items have been destroyed, when and whose authority evidence has been destroyed. Because listen to this. Everything miraculously is getting destroyed, right? Well, to this day, okay, the defendant has never been told who authorized this shit to be fucking destroyed. I want to know. Wouldn't you want to know? I want to know. Special responsibilities of a prosecutor, rule approved by Supreme Court effective June 1st, 2020. When a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a defendant did not commit an offense of which the defendant was convicted, the prosecutor shall, if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense that the defendant did not commit. The new evidence set forth in Claim 2, which petitioner had not yet obtained at the time he filed his DNA motion, shows that there is a reasonable probability a target bag and duct tape wrapped around it. So I was wondering and waiting when we were going to get to this Target bag because it's in the book that my homie wrote. And I was like, oh my God, he tracked down that Target bag and like a ton of shit that was going. I was like, holy shit, here we go. This Target bag and the duct tape that was wrapped around it, which were located along the shoreline approximately 100 yards north of Lacey's remains, in the direction of the location where Connor's remains were, and which had a strong odor of decomposing remains, which were related to the death of Lacey and Connor. I mean, come on. New evidence now shows that Lacey was likely put in the bay at or near the Albany Bulb and then migrated north to the location at Point Isabel where her remains were recovered. This new evidence supports petitioner's arguments that DNA testing of those items could yield probative evidence and help identify the perpetrator or perpetrators of the crimes of which petitioner was wrongly convicted of. The SCDAO should stipulate that it is in the interest of justice to conduct additional DNA testing on those items as well as on the mattress fabric itself. See rules of professional conduct, bitches. When a prosecutor knows of clear and convincing evidence and establishing that a defendant is in the prosecutor's jurisdiction, again, talking about that shit. So petitioner here will renew his motion for post-conviction discovery seeking MPD's EPRs based on recently discovered evidence showing that MPD began destroying evidence in May 2003 and continued destroying evidence at least through 2010 when the evidence collected from the orange van was destroyed. Petitioner needs to obtain the EPRs so a complete investigation into what evidence may still be available for DNA testing and what other items of evidence the prosecution has destroyed, in addition to the January 2nd videotaped interviews with Todd and Pierce, the Medina safe, and the physical items of evidence collected from the van fire, which the prosecution destroyed in 2010, without explanation and before petitioner's direct appeal to the California Supreme Court had even fucking begun. There was shit that was destroyed before even trial started. Petitioner identified a significant number of gaps in the discovery the defense was provided at the time of trial and asked the court to order the prosecution to provide him with specific items he identified as missing or not provided at the time of trial. This was during a post-conviction discovery motion. The reply to that motion, a large number of requested items related to exculpatory evidence, Brady materials that appeared to have never been either collected or were suppressed, hidden, or destroyed by the prosecution. The prosecution argued that petitioner was not entitled to any of the discovery he requested under that section code, and that the court should deny the motion in its entirety. Well, on July 16, 2024, after briefing by both parties in arguments on petitioner's motion for section post-conviction discovery, Judge Hill took petitioner's motion for post-conviction discovery under advisement. On October 7th, 2024, Judge Hill granted petitioner's motion in part and ordered that the prosecution to produce certain items of discovery to petitioner. On January 6th, 2025, the prosecution filed a compliance brief with its discovery response. The response was lengthy. So 6 months would go by. Okay, here, we gave them all of our shit. Then on March 1st, 2025, petitioner informally requested the following follow-up items of discovery based on the prosecution's January 6th, 2025 responses. On March 1st, the petitioner requested that the SCDAO confirm what interview tapes with Todd and Pierce were delivered to the SCDAO on February 7th, 2003. That request was denied. It's no doubt in my mind that in those interviews, those recorded interviews, that the video recording or the audio recording of those interviews of those robbers, 100% Lacey's name's all up in that shit. All up in that shit. Now, the Los Angeles Innocence Project post-conviction investigation fact witnesses, since they've taken over, not that long ago, since they began investigating the evidence in this case in 2023 at the end of the year, counsel has interviewed over 100 fact witnesses in an effort to learn the truth about what happened to Lacey and Connor Peterson. 100. Okay. Fact witnesses. A number of witnesses have reached out to counsel directly with information about individuals believed to be responsible for these crimes. Several witnesses agreed to sign sworn declarations memorializing the events they recall related to this case, and those declarations are presented with this petition. A number of witnesses expressed fear about their safety should they come forward with the information they have to share. Some witnesses, whom counsel confirmed were living in or around Modesto's airport district in 2002 when these crimes occurred, shared with counsel that they have material information about those responsible for these crimes. But when it was time to meet with counsel for an in-person interview, the witnesses apparently got cold feet and did not show up at the scheduled meetings, and then stopped responding to counsel's efforts to reach them. These people are being reached by powerful people. That's what's happening. Thank God there's some people that they were able to get stuff out of. A constant refrain counsel has heard throughout its investigation from witnesses who were living in and around Modesto's airport district when these crimes occurred is that it appears to be common knowledge in that community that the petitioner did not commit these crimes. The new evidence presented herein leads one to conclude that someone other than petitioner committed these horrific crimes and that the person or persons have not been held accountable. Now, the next episode, we jump right into, the the factual overview, which gets into Scott and Lacey, and we're going through the factual overview, and it is absolutely going to blow your mind, at what transpired. Again, Scott Peterson did a 120-page declaration. With that said, I want to end with...
I'm glad she did the press conference. I'm glad that's out there. It had nothing to do with Lacey's disappearance.
Your stomach must have been turning, though, when you see her go on television, and it's national. And here's this girl saying, he lied to me. He told me he was single.
Sure.
I mean, your stomach must have been turning.
You know what? It was a positive to allow us to go on to search for Lacey. That's how I view it, and that's how I felt about it.
The Rocha family
I said, good, this will be done, and we can keep looking for Lacey.
Now, you know Lacey's family says they can no longer trust you.
Mm-hmm. It was unfair and inappropriate for me to have that relationship.
How do you feel, though, that, the Rocha family says they can't trust you?
They're wonderful people, the Rocha family. I know that, we all have love between us, and I know that we'll all keep searching for Lacey. And, I told Lacey about the relationship. She knew about it, and it's important between us. And we'll continue to search for her. We'll bring her home.
That's another problem people had a big issue with. A lot of Lacey's family talked to me and friends saying, if Lacey knew that you were having an affair, she would have said something to someone. She wouldn't have kept quiet about it.
I don't know if she mentioned it to anyone or not. I did see a report in the...
All right, guys, I'm going to give you guys a little spoiler, before I start my 10 p.m. episode that jumps right back into it. Here is a spoiler, something I had never seen before. I'm a person that pays a close attention, and I'll be using Hector here because at the end of my episodes, I'll use Hector, and I'm going to show you all the pictures that I have from the documents. When I was reading, and I actually got to see a picture of the kitchen, and it was a very specific part of the kitchen, though. And the part was over by the kitchen sink, where there was a window over the kitchen sink, and then to the right and left there were 3 glasses, and then to the left there was a Bretta, like the water, like a water filter. And I want to read something for you. Something made known by Scott Peterson to the detectives was, hey, is anything out of place? Like, the house is in pristine. Okay. They were very tidy, you know? He said the only thing that seemed out of the ordinary to Scott was that it appeared that Lacey was putting in a new Brita water filter and was possibly interrupted by something, because there were 3 full glasses of water and what appears to be 1 empty glass sitting on top of the counter near the Brita water pitcher shown here in this photo. It was out of character for Lacey to leave home with an unfinished project lying on the countertop like that. Investigators did not collect the water glasses shown sitting on the kitchen counter near the Brita water pitcher as evidence, nor did they analyze them for fingerprints. But guess what? See www.brita.com support water pitchers, instructing users replacing a Brita water filter to discard your first 3 containers worth of filled water or use it to water plants. It's normal for carbon dust to appear in your first few fillings. I was like, holy shit. Okay, now I said, well, if you guys can remember the house, what does the window overlooking? So Lacey was somebody that would be getting involved, and if she saw something going on in the neighborhood, she was like the watchdog of the neighborhood. You guys are going to hear about this coming up. So she would, if she saw something, she would go out and just like get right in the mix and be like, hey, whoa, what's going on? Or like, you know, go up to people. She had no problem. Like when she would see transients in the park, she would tell them to get the fuck out of there. Like homeless people, like just like laying around and shit. So I walked that park. Actually, I walked that park with Miss Vargas, who, by the way, dude, she's still fucking sick as a dog. I don't know what she's got. Hopefully it's not COVID. And she feels awful, by the way, as well. So when we were walking through that park and whatnot, yeah, I was like, yeah, I can see, you know, but here Lacey going up to people, she would just be really vocal and just say like, whatever. So Scott says this, like, hey, the only thing that seems weird here is this is how, when we're going to be changing a filter, like this is what we would do. We would put them in 3 cups like this because we got to like pour it all the way through, and you just want to like clear out your filter, and then we would leave those. And so he's like, it's weird that the weird part is that the Brita was not put back into the refrigerator. Okay. And so it wouldn't be the part that the glass, because if you want to save those, so like pour them into, you know, plants or whatever. But they didn't even get to that part of talking about the conversation. They just shut him down. But literally, she was really, you cannot make this shit up. Here's the picture, and it's all right here. There's the water. There's the Brita. There's the 3 glasses. There's one that's not, you know, not even, there's nothing in that one. And then it's like, yeah, why wouldn't she be putting that back? Well, what did she see out the window? What could she see out the window? And what did she go out there and be like, what the fuck's going on here? Because she knows that her neighbors are gone. She sees this van, she sees another car, and she goes over there. Totally not even fucking like brought up, made a statement about, but that tells me that she was interrupted while doing something, right? Okay. And that she walked away from what she was doing and never motherfucking returned from that. And, I mean, oh, and the other thing about the dog being returned, wait till you guys hear about that. Everyone's always assumed that just because the dog was out, that Lacey was dead already. Do you understand that Lacey's dog, their dog would get out all the time? And they would just, like, it's not like, here, I have to find your owner to give. Nope. Open up the gate, put Mackenzie back in there, and then close it, and then, you know, go. So, all right, we'll see you on the next one.
News interview with a friend of ours, Lori, that indicated that she did not believe that I had told Lacey. Lori also said, I know Scott, and he had nothing to do with her disappearance. And that statement to me is what's relevant, because you can, okay, question my morals and my poor decision making. That's fine, but don't stop looking for Lacey. She's out there somewhere. She shouldn't be. She should be with our family.
You mentioned.
So let's keep working to bring her
I
home.
know that you mentioned during the network interview that only you and Lacey know your marriage.
That's correct.
Explain that.
Just as anyone's intimate relationships, it's it's between those two people. And yes, you share things with people, and some things you don't share with people.
Now, did Lacey find out about the affair, or did you just come out and tell her?
No, I informed her about it. I don't believe she knew.
Why come out? I mean, what made you say, I'm going to tell her today? What made that day the day to tell her?
Just because it was the right thing to do. And as you know, when you're not doing the right thing, it just, eats you up. You feel, sick to your stomach, and you can't function, and you have a hard time, looking at someone.
Right. You mentioned it was the right thing to do.
Mm-hmm.
But from my understanding is that after you told Lacey, you continued to see Amber. Was that also the right thing to do?
I saw her, yeah. No, it was not.
Explain that.
That is the explanation. It was not the right thing to do.
But you continued to do it.
Right, and it was not the right thing to do.
And then even after Lacey went missing, you continued to romance this girl?
No.
She claims that you called her on the 24th and told her.
I informed Amber about Lacey's disappearance and the fact that I was married.
On the 24th?
No, not on the 24th. I believe it was probably it was a few days after.
She says that you called her on the 24th, December 24th, and told her you were with your parents in Maine. Is that
Okay.
true?
I called her and informed her about Lacey's disappearance.
On the 24th of December?
No, I did not. It was a few days after that I called her and told her I was married.
Okay. But
No.
she claims, let me just finish. She just claims that you called her on the 24th, told her that you were going to Maine, you were visiting your family in Maine, and then you were going to Brussels.
Gloria, I'm not going to waste what little media time we have, and in this forum, with, this is a short newscast, and I don't know how much of these words you're going to use or not, but I'm not going to waste that by defending myself or talking about irrelevant things. It's better served if we talk about what happened and where's Lacey.
Okay.
So the facts are that we know that on Christmas Eve, I left the house here around 9:30. She was here in the home. Okay, that's a fact that has to get out there because it's been reported erroneously that I saw her leave the house. Okay, she was in the house. It's one thing we know. Second thing we know is that the dog was returned to our yard with its leash on at 10:30 by a neighbor. Those are the two things we know about her disappearance. And hopefully those can help some people. There are things that we need to get out there are the tip lines, which is the Modesto Police Tip Line, 209-342-6166, and also 1-866-LACI info, LACI info. And that's a tip line for people who have talked to the police. Even if they talked to them, please call that tip line if you saw her that day, if you've seen her since, or if there's something you think is important in the neighborhood.
You guys, scientific evidence has now emerged. This is wild for me, is that she was alive. Okay. And, I was just reading her spoiler is that, did they ever think about having a ransom? Was there a ransom? Was there ever a ransom? And the police buried it. But Lacey 100% was alive for at least, like I said, the 20. So this happened on the 24th. So the 25th, 26th, 27th, 28th. All the way more looking forward, like January 1st. And if you actually read the book and what these motherfuckers were doing in that area, like, these cops, man.
We want to be very specific.
Okay.
The other big push that we need is LaceyPeterson.com. People can go there and print off the flyers and distribute those into every medical center, bus stop, high traffic area in the nation, because it could be the next flyer that brings her home to our family.
And I know more than I know that you want to find Lacey, and the second thing you want to do is clear yourself from suspicion, correct? I mean, that is, you want the focus back on Lacey and not on you.
I want people looking for Lacey because they're not doing that right now. And that's why I'm sitting down with you in hopes that people will go, you know what? If I think he had some involvement, if I don't think he had some involvement.
And here they were running around saying that that burglary happened on the 26th. They could have been over in that airport district, fucking knocking down on doors, going in those places. They did nothing. And that's why I want to look deeper, because I believe that there's some connection with what was going on in that area, and that 100% police were purposely looking the other way, and they were getting cutbacks. They were getting their kicks, however they were, with the drugs, with the meth. And these were these people's CIs. So we'll be back later. Thanks so much. Appreciate you.
Doesn't matter, because Lacey is what matters, and she's out there missing, and she needs to be home with her families. So I don't care to defend myself. I don't care what people think of me. You know, as I've said, question my moral character if you want to, but look at your heart, think of Lacey, her picture, baby, and make the effort to bring her home. And that's a simple reality. That's a simple thing we need to do. Just, think whatever you want of me. As long as you're out there and you're comfortable with yourself, that you're doing what you need to be doing to find Lacey and bring her home.